This is Earl White, real estate attorney. This video is about tenant estoppel certificates. We're going to cover what is a tenant estoppel certificate, situations where a tenant estoppel certificate is used, and negotiation considerations for the buyer and the seller in real estate transactions. First, what is a tenant estoppel certificate? A tenant estoppel certificate is a document signed by a tenant that restates the material terms such as rent, security deposit, options to renew. It's produced as part of a real estate purchase transaction commonly, and it also verifies seller representations so the buyer can feel comfortable that what the seller has stated as part of the transaction is accurate. Next, when is a tenant estoppel certificate used? More often than not, it is used as part of commercial transactions with large commercial tenants or significant commercial tenants for the size of the building. It may not be practical for a mall when there is 100 stores to get tenant estoppels for small stores. It is often not practical for residential buildings where you're not going to get small tenants to, at least a large percentage of them, to be able to sign tenant estoppel certificates. So most common for commercial transactions where there is major tenants and maybe you don't get every small tenant to sign it. Negotiation considerations for the buyer and the seller as part of these negotiations for the tenant estoppel certificates is first, the buyer. Why do they want tenant estoppel certificates? The seller has a motivation as part of the purchase and sell transaction, obviously, to extract the highest purchase price they can get for the property. If they were to make negative disclosures about the tenancies of the property, this is going to lower the market value of the property. So they will either want to shade, or false representations is maybe too strong, but they'll want to certainly shade the representations to be favorable to the seller. And I guess there also could be false representations, which would be fraud, but that's a possibility. So the buyer protects themselves against either inaccurate or wrong representations by the seller. On the other hand, sellers would want to limit the requirement to produce the contractual requirement to have to obtain these tenant estoppel certificates, so they do not find themselves in breach of contract or creating avenues. For example, if the contract provision says the seller must, at the time of closing, produce the tenant estoppel signed by a tenant, tenant may refuse to sign it for whatever reason, or at least in the time frame that the buyer is requiring it. And in that event, the seller can find themselves in breach of contract by not being able to produce it for reasons that may perhaps beyond their control. In addition, the failure to produce the tenant estoppel or to produce an estoppel certificate that has materially different information than provided by the seller in a negative way creates the avenue for the buyer to cancel the transaction and just waste the seller's time, and that is obviously not ideal. So that'd be another reason the seller would want to limit these tenant estoppels. For a couple of general negotiation points, it would be very difficult for the seller to get tenant estoppels for everyone at a building if there are many units. So what you can do as part of the fairness, part of the negotiation, is limit it to a certain percentage of the units that must produce tenant estoppels. Maybe that's 50%, or maybe that's 75%. In the same token, you can also limit it to which tenants have to sign the tenant estoppels. In that case, it would most likely be the most significant tenants at the building, as opposed to the smaller ones, and most likely the commercial tenants and no residential tenants. The seller may also protect themselves if they contractually agree, they can protect themselves by limiting their liability if they aren't able to get the tenant estoppel certificates. If you aren't able to perform and get those documents, then the limitation on liability can be no lawsuits, no damages, but rather the buyer's sole remedy is to cancel the transaction with the return of their deposit. And in that case, at least the seller doesn't find themselves in a lawsuit or incurring significant damages by being in breach of contract.